Thank you for joining us today. We're going to jump into things. Every week we discuss about estate planning, legacy planning, and planning for your future. And this week our topic is basic estate planning, and specifically we're going to talk a little bit about the importance of having a general assignment of property for your revocable living trust. When you establish an estate plan, one of the things that a lot of times we find clients forget about is the idea that their plan has to be properly funded. And what exactly does that mean? Well, properly funded means that you have to have the property that you want to be protected from the court system, from probate, and to be transferred according to your plan. That property needs to actually be inside of your revocable living trust. If it's not inside of your revocable living trust, then the trustee doesn't have any authority to manage it or to be able to make decisions regarding that property. So in order to put it into your trust, there's three types of property that you're going to be dealing with. There's real estate property, which will need to transfer title and actually be owned by the trust. There's bank accounts, retirement accounts, life insurance accounts, any of those sort of assets which have the ability to name a beneficiary. And generally speaking, what you would do is change the beneficiary on each of those accounts to your trust so that if something does happen to you, then your trustee has the authority to make a claim on those accounts and to get access to the assets in order to distribute them or in order to follow what the plan says. But then the third type of property is what we call personal property. And personal property can be anything from tangible, movable assets, such as jewelry, your laptop, your personal belongings and items, household items. But it can also be, other personal assets that the law considers to be personal property. And it's very difficult to put jewelry or a tangible asset into a trust via title transfer or via a beneficiary declaration. So what we do instead is we do what's called an assignment of property. And that general assignment of property says that you are exercising your rights as the owner of those assets, and you're putting it into your estate plan, or specifically here, into your revocable living trust. That declaration serves as the transfer of those assets into the trust. And if anything were to happen to you, your trustee could rely on that declaration to be able to distribute those assets or manage those assets according to the terms of your trust document. So why is this so important? Sometimes we see clients that have done a estate plan or revocable living trust, and they don't have these sort of general assignments of property in their binder. And for the most part, it may or may not really make a difference. Some trusts have that declaration embedded in the actual trust document. Some trusts rely on a separate document, and some don't have it all together. But the reality is, in order for you to be able to rely on that general assignment as a transfer of assets, especially if somebody were to contest the document, then it's important to have that declaration and for it to be signed and for it to be notarized. So the general assignment declaration basically says that any tangible property, any assets that you own, any items that you own are all assigned to your trust. And it can be as specific as naming, property in particular, or it can be very general and very broad. And sometimes we have clients ask us, well, what about my cars? I have a truck, I have a car, I have, maybe some off-roading vehicles, maybe a boat. How do I get those things into my trust? And those are all tangible personal property. So they can all be put into the trust by general assignment. We can even specify that you're transferring all those vehicles and items into the trust by general assignment. They can also be transferred by transfer of title through the DMV. But if you do transfer title with the DMV they don't know the difference. They just name between, from one much the same whether you do it before you pass away or after you pass away. If you have less than 3 vehicles, we usually don't even recommend making a change to the titles on your vehicles to your revocable living trust, because there's really no need to. The process of transferring them, if you were to pass away, is going to be exactly the same as it would if you were to do it in the first place, when you establish your trust. So therefore, a lot of times we will simply recommend doing the general assignment and relying on that for the transfer of your vehicles. But if you have over 4 vehicles, this becomes a little bit more complicated. At the time you're ready to transfer it into the trust passing away, that's when it makes sense to transfer 1 or 2 of them down 3 into your living trust beforehand. So your general assignment is something that can be relied upon. So a challenge is documented. Maybe somebody that says, oh, well, this was been to me by so-so, and it's not subject to trust. They prove that was an actual gift, that they have a declaration of gift or something. It's just general thing to be relied upon as evidence that it's in trust and not, somebody else's possession. The general thing to be relied upon in certain instances to avoid probate in the case of the trust failing to own or total property. For example, if you're in the state of California, the process that California has developed to avoid a full, prolonged, formal probate process. Somebody had a revocable trust, and they didn't put property to their trust for whatever reason. Maybe it was forgotten about. Maybe they overdid. Maybe it was right after the trust was formed. Whatever reason. And then that process is called a Hegstead petition. So a Hegstead petition allows you, for example, to transfer vehicles that should have been in the trust, but for some reason it was overlooked or was left out of the trust, or maybe you financed it, and because of your trust, they didn't put it back in. And normally I would have to go through a full probate, but you can go through a process under a petition to simply transfer it into the trust on a more streamlined and informal basis. In order to be able to do a Hegstead petition, you have to show intent for your assets to have actually been in the trust. So a general assignment, especially if it's broad enough to include real estate, can be relied upon for a Hegstead petition. In other states, a similar sort of concept prevails where you don't specifically say that your property or personal property is intended to be in the trust. The assumption is that it's not, right? You have to specifically say, I want this to be owned by my trust. So a general assignment is broad enough to say, well, I want everything I own to be in my trust. And to the extent that makes sense, that can be enforced, or it can be at least, utilized as evidence to So we've had a situation, actually recently, we had somebody call us and they said, I completed a trust plan, or rather, my father completed his trust plan. He had this trust. He's had it for a long time. He wanted to make a couple changes. But as far as we know, nothing is in the trust. So he hasn't put his real estate into the trust because he had done a refinance and they had taken it out and they forgot to put it back in. And then he has a few vehicles. He has, some savings accounts, and he has just odds and ends, personal belongings that they have in his home. And they want to make sure that, because they have somebody in the family that is likely to go into the house and take things without any of the siblings, they want to make sure that the trustees are in full control of all the assets of the trust, that there's no question. Well, one of the things we got was whether you had to add a general assignment of property to the trust, and they didn't, unfortunately. So that's one of the things that we helped them to do, is to do a general assignment. We specifically said in the general assignment that we wanted to transfer vehicles into the trust. We also specifically said that we wanted to make sure that any assets that were not, at the time of the declaration, currently in possession of somebody else that have, been gifted, that all of those assets are to be considered part of the trust, and nobody else has any rights to remove them or to do anything with them aside from the trustees under the terms of the trust. So, the general declaration seems like a very insignificant document in your big trust binder with all of the other things that are included, your powers of attorney, your healthcare director, your wills, your trust. It's an insignificant document. But it can be very useful and very significant under certain circumstances. And so we recommend that you have a general assignment. And then if you have a general assignment, don't just rely on your general assignment. We have some individuals that have to say, well, I have a general assignment that links everything I own is in trust. Everything. It specifies accounts, real estate, everything. Unfortunately, under the law of most states, that's not enough for it to actually be in the trust. Under a lot of those states, you need to rely on beneficiary declarations for accounts, and those are going to go before a general assignment control. You also need to rely on the actual ownership of who's on title assets. So we talked about the Hexstead petition in California. Actually, it's a similar process to form probates or streamline probate processes when something's left out of a trust. But the idea is that you still have to go through the court system in order for those things to function. It's better not to go through the court system altogether. The purpose for most of doing a living trust. So in order to avoid that altogether, you need to make sure that the property is titled. To declare in your trust that I have a home at this address, and it's in my trust. That by itself does not control the transfer of home. It actually needs to be titled in your trust in order for the trust to have control over it. And if it's not titled in your trust, then that declaration may be relied upon to put it into the trust, but it will have to go through a court process to do so. So, it's not a silver bullet, but it is something that's valuable, and it is something that's important to have in place. And if you've done a trust plan in the past, we recommend that you go back and look and see if you have a general assignment of property to your trust. If you have a general assignment of property to your trust, we recommend that you also go back and see if all of your assets are properly funded to your trust. Have you transferred into your trust so that your trustee can rely upon the trust document and distributing them and being able to manage them and administer them if something were to happen to you? And then finally, if you've reviewed your plan, you had your alignment. I recommend that you look at, and this is something that we'll talk about in the future, that you look at how you want to specifically leave the tangible assets to individuals who have a declaration known as a property memorandum to do that. But the interesting thing is that the biggest fight, and this is according to an LA Times article just a few years ago, the biggest fight about that being the biggest fight about usually hard personal law is when you fight over a hairbrush, fight over a horse, they fight over mom's jewelry or dad's cousins. That's where the big fight end up happening, and it's because the plan didn't consider those assets or the individuals. These are emotionally charged items. Who would want them and who they want to have them. Those are things that we encourage you to part of your state plan. As we said, in the future, we'll be more about a personal memorandum, how to specify what items to leave to individuals. And then feel free to subscribe for us wherever you make your podcast. And as always, we'll be here this week to discuss some more about planning. Planning, and specifically next week about business succession planning. So thanks again for plugging in, and